100 years ago, a small town courtroom in Tennessee became the battleground for one of America's biggest debates: evolution versus creation. Teachers, preachers, scientists, and reporters all collided in the Scopes monkey trial. What happened when faith met science under the spotlight? Don't miss today's discussion. Welcome to Faith and Politics, a show dedicated to discussing issues surrounding the intersection of church, state, and politics, and the examination of whether you're allowing your faith to shape your politics or are your politics starting to shape your faith. In other words, what do you do when God and government come face to face? I'm your host, Orlin Johnson. Let me introduce you to our guest panelists that we have with us today. First, we have Mr. Todd McFarland, General Counsel of the General Conference of the Seventh-day Adventist Church. We have Mr. Tim Schultz, who's president of the First Amendment Partnership. We have Mr. Andre Wong, who's the general counsel of the North Pacific Union Conference of the Seventh-day Adventist Church. And we have Mr. Vi Luis, who is the Indiana Conference Public Affairs and Religious Liberty Department Director. Gentlemen, great having you here and looking forward to our conversations today. You know, it's been about 100 years, which marks the anniversary of the state of Tennessee versus John Thomas Scopes, often called the Scopes monkey trial. At the trial, questions of science, religion, and liberty took the national stage. Charles Darwin proposed a theory of evolution in 1859. It suggested all creatures evolved from a single-cell organisms. According to this theory, humans and apes share a common ancestor. Most Christians believe that this contradicts the Bible's account of creation. In 1925, Tennessee lawmakers passed the Butler Act. It made teaching evolution illegal in public schools. And lawyers at the American Civil Liberties Union believed the act to be unconstitutional. They wanted to challenge it in court. To do so, they needed somebody to actually break this law. And in Dayton, Tennessee, local leaders saw a chance to put their struggling town on the map. You know, Tim, when I think about the Scopes monkey trial, what's interesting to me is it was probably considered to be the trial of the century, the first big-time national stage legal proceeding. And imagine that what it was about, the Bible versus evolution. And when you think back to how it's shaped even what we do today in the era of faith and politics, this seems like this might be where it all began.
Orlin, I think that really, among other things, this trial proved that celebrity-driven, high-publicity courtroom trials are not really the best way to come to the truth in a complex debate like the one there between science and religion. And I think that those things tend to emanate more heat than light. I think if we think to our best sort of modern example, the O.J. Simpson trial, there were lots of social issues being kind of litigated there, issues around race and policing, and those are real issues. I mean, that's why they had traction in the trial. But a trial itself about discrete legal issues is not really the best way to kind of settle those complex realities at a societal level. And when you try to shoehorn them in to a trial with its limited rules of evidence and its sort of limited scope, forgive the pun, it's just not a good vehicle for discerning truth. There's a lot more to say about that, but I think I would just sort of start with that as my kind of opening lament about the kind of legacy of the Scopes trial.
No, Vilo, what are your thoughts on that? It's something that I guess almost is the beginning of the battles that we have today regarding what should happen in school. How does religion play in it? How do you kind of take a look at this?
One of the things that I see today is such a great lack of civility in our culture. You can't talk without being seen as disagreeable, and so But I think it probably had a lot of its foundation there in the Scopes trial, and I would like to see a little bit more civility, a little bit more respect for different points of view. But today, if somebody doesn't like what you say, they want to trash you rather than talk civilly and responsibly about the matter.
You know, Todd, it seems like in public schools right now, we're still kind of battling as to what really should happen there. I'm trying to wonder if scopes what's happening today regarding creation versus evolution with today's politics. I wonder what the battle lines would really look like.
Well, yeah, I mean, first of all, as we know, subsequent to this, the Supreme Court sort of answered that question in the 1960s, right? And said that, the creationism is, religious, not scientific. I think the battles in many ways have moved beyond that, right? So there's really no question almost every public school teaches evolution to some extent. Ironically, what this has done, though, is it has started a trend of moving faith and belief more and more out of the public sphere. So it wasn't just about like, oh, we're going to teach science versus faith. It was also the beginning of, and this has been something ACLU's had a very clear agenda on for 100 years, of trying to get religion and faith out of the public area. And you see now public schools routinely exceed their authority when it comes to faith in school. So, for instance, students who are allowed to, pick a book to give a book report on, you can pick any book you want except a religious book. And then the teacher will say things like, well, you can do the book, but you have to give the report just to me and not the classroom and stuff like that. And that balance is one that public schools rarely get right.
You know, Andre, it wasn't long before that trial got started where William Jennings Bryan kind of wrote, if the Bible cannot be taught, why should Christian taxpayers permit guesses to be taught? And it seemed as though he was really distinguishing or really taking shots at evolution, saying that this is just a guess, but I guess the Bible's not a guess. And so the question really is that this was starting to really push faith out of the public sphere. And now it seems like 100 years about later, we're starting to drag it back in, probably in a more serious fashion.
Yeah, the trial really crystallized the conflict between two visions of the American identity. On one side, you had those who believed that religious tradition must guide public life, including how children are taught about the origin of man. Then on the other hand, you had those that embraced scientific progress and saw evolution as an essential component to modern education. So, in the decades after the trial, the courts have interpreted the First Amendment to require government neutrality between religion and non-religion. And so really the impetus of the trial focused on foundational issues: religious liberty, church-state separation, academic freedom, and we're seeing these issues being resolved in favor of protecting scientific curriculum from sectarian control. So, the trial is obviously more complicated and left an enduring cultural footprint, and has touched a nerve in religious communities that traditional beliefs were being marginalized by a legal system that treated religion as something to be kind of fenced off from public policy. And so that sentiment continues to shape our political coalitions, educational debates, and religious freedom claims to this day.
And Orlin, I actually think that there's something in this trial that goes beyond sort of science versus religion. It goes to this question of populism, right? It goes to the question of elites versus populists. Who's sort of qualified to run your life? And I think we see that in some of the battles between, today with populism and science. So, William Jennings Bryan was known as sort of the most famous populist of his era. There was this whole question really there as to whether sort of ordinary people are sort of fit to run their own lives in their own ways, their own folk ways, or whether it's the sort of cultural and intellectual elites who sort of saw in Clarence Darrow their champion. And I think we see that continuing in a way to this day. When you have questions about who is most qualified to decide during the COVID epidemic how long schools are open and closed. Is it the new clerisy of public health figures, and their sort of groupthink, or is it ordinary people who can kind of make those cost-benefit decisions better, than the so-called pointy-headed elites? These sorts of debates between populism, sort of regular folks, vis-a-vis the kind of, the clerisy of credentialed scientific and media elites that tend to be concentrated on the East Coast. I actually think that's the part of the trial that most sort of resonates today, because you can see the kind of contours of that being repeated over.
You know, Todd, it's interesting because that question regarding trust is what we're still battling today. There was a time you would wait to see what a judge said, or you would wait to see what an expert said. But in the social media world right now, you have influencers who don't know a whole lot that basically can be shifting the narratives and the conversations. And now the question is, who do you trust in social media kind of will rule the day, as opposed to who real experts are in these things?
Yeah, there's no question. I think that experts and elites have lost a lot of ground. I think that goes for several reasons. I think different worldviews play a part. I also think that, populist ideas have started to realize that these decisions are not governed just by scientific fact, but also by political ideology and by, sort of values, and those are baked in. One of the worldview issues, though, is, the scientific community feels like when they, discover new information and change a theory, change the, masking regulations, or change, the distancing, or change, other stuff, that reinforces the scientific viewpoint and makes their views stronger because it shows, well, we're open to new ideas and so forth. A lot of people, on the other hand, view that as like, well, you just don't know what you're talking about, because if you knew what you're talking about, you would have gotten it right the first time.
Right.
And so I think that sort of differing views of how society, of how you view a process informs a lot of the debates that we have now. And, there does need to be a view of science in society. We have a lot better society. People are healthier now. People live longer. People have better lives for the most part. But you can't just turn your life over to elites.
Vilo, you kind of mentioned this was kind of national news, imagining national news 100 years ago as opposed to today. The idea that this really touched everyone almost in this conversation, because there was really only two sides. You were either for creation or you were for something else. But now it seems like we got so many different pockets. Who knows what side you're really on anymore?
That's true. And a lot of people think, well, the experts have all the answers. Well, they may not. And one of the challenges we've had for those especially that believe in creation is that not always has that investigation been done carefully and being done right. And I know a professor Dr. Art Chadwick from Southwestern, that he's very, very insistent that our methodology be sound. And so, it needs to be credible. And as Christians, we need to do our work well.
The one thing that this trial has done 100 years ago was normalize or even inflamed the idea that robust public discourse about religion, science, and conscience is part of a healthy democracy. And we have a struggle in doing that civilly. And so really the legacy of this case is not simply just a victory of one side over the other, but kind of an enduring reminder that pluralism requires both constitutional guide rails and a cultural willingness to live with that disagreement.
Well, and I think I'm going to let that be the last word, Andre, because what's really important also is the ability to be able to really have differences of opinion, understand that there's always more than two sides, being civil in our discourse as we go about having more and more conversations. But at least this trial got everyone started with saying we can take this conversation to the public. Now that we have it in the public, we've got to figure out how to get the public to behave themselves when we are having these conversations. Coming up, Sisters of the Poor are battling in court for protection to uphold their religious beliefs. Stay tuned to hear our discussion. When faith and government collide, the issues can be complex and consequential. Faith and Politics explores how religious conviction intersects with law, policy, and public life, offering depth, balance, and clarity with meaningful discussion and trusted insight. To see a bunch of our previous episodes, check us out at faithandpolitics.tv and subscribe to us on YouTube. It may seem like you've heard about this case before, But we're getting ready to hear about it again. The Little Sisters of the Poor versus the Commonwealth of Pennsylvania. It seemed like back in 2020, the Supreme Court ruled 7-2 in favor of the Little Sisters of the Poor, allowing them to continue serving the elderly, poor, and dying without threats of millions of dollars in fines. Writing for the court, Justice Thomas said that for over 150 years, the Little Sisters have engaged in faithful service and sacrifice, motivated by a religious calling to surrender all for the sake of their brother. But for the past several years, they, like many other religious objectors who have participated in litigation and rulemakings leading up to today's decision, have had to fight for the ability to continue in their noble work without violating their sincerely held religious beliefs. Todd, I don't know what's going on here, but I thought we had the perfect individuals or organization that you can make this ruling, but it seems like every couple of years or maybe even every 18 months, we're right back in court discussing this. What's going on here, and will this ever stop?
Well, Orlin, what's going on is district courts just can't get the message. And for some reason, the people who the left leads to attack one of the best defendants or plaintiffs you could have, the Little Sisters of the Poor, right? So, the underlying issue, of course, just to remind everyone, was whether or not an employer, an organization has to have or fill out forms for a contraception mandate, right? Mm-hmm. And the Little Sisters of the Poor says, well, that violates our religious belief. They're Catholic when it comes to contraception, and so they ask for an exemption. And it seems like even though the Supreme Court said 7-2, the lower courts have not gotten the message. And it's hard to understand what's really motivating this, other than just a desire to sort of enforce a particular ideology on society and on people who object. Because the important thing to understand here is the government had found ways to provide the contraception to women who wanted it and needed it, right?
Yeah.
So this was never about, could women actually get access? There was ways around that, and they found ways to do it that didn't violate their belief. Instead, it seems to be more about making people bend the knee to a particular ideology.
Yeah, well, in the words of Ronald Reagan, there you go again. Yeah, here we see the Little Sisters of the Poor back in our courtrooms and appellate ladder. But this new ruling didn't attack the idea of religious exemptions themselves. Instead, the federal trial court judge said that the agencies didn't follow proper administrative steps, that the rules were too broad and not adequately justified under the Administrative Procedures Act. And so, boom, the exemptions were vacated nationwide. So for the Little Sisters today, the impact's immediate. They're back where they were years ago, facing the possibility of being required to offer coverage that they believe violates their conscience or face federal penalties. So for religious nonprofits across the country, this decision now creates, again, the uncertainty into how they plan health coverage for their employees.
Tim, lots of these cases I always think are up because people are looking for notoriety. I'm beginning to wonder if district court judges are looking for notoriety at this point by coming back with these decisions that it seems have already been settled at the Supreme Court level, but it's like they decide, you know what, this will get me out there, and even though we know where this probably ends up, we're right back in court again.
Well, I sort of have two thoughts about this. One is that if you've ever been involved trying to help somebody who's fighting the government in religious liberty litigation, as Todd has, a lot of litigators will say things like the process is the punishment, right? So yeah, the Little Sisters of the Poor continued to win in front of the Supreme Court, but this process has itself been a kind of a punishment. The other thing I think you could say is if you just look at sort of top line Supreme Court results over the last decade, we have had victory after victory after victory in the United States Supreme Court for religious liberty. There's been a big winning streak over the last decade. But if you go over to the Beckett Fund, they have more people working there than they ever have before, and since I've been working with them, which has been for 12 years. And why is that? Because there's more challenges and problems. So what can be true at the same time that, yeah, on the one hand, religious liberty has been winning in the U.S. Supreme Court. On the other hand, the challenges are also greater and come more often than they ever have. And that is actually perfectly symbolized by this case. As Todd said, you have the most sympathetic defendants in the history of religious liberty litigation, the Little Sisters of the Poor. And yet there are people who are so ferociously ideological, right, that they would continue to make the Little Sisters the poster girls for religious liberty, which is exactly what we would want, right, as religious liberty advocates. But they're just so ferociously committed to this idea of forcing contraceptions on people that they continue to do it. And so I think this speaks to a much bigger set of issues, and in a way, much like the Scopes case stood for a much bigger set of issues.
It's crazy because, you also have the 2016 case with Burwell, where the Supreme Court ordered the government to find a way to accommodate them. And an interesting irony, Little Sisters of the Poor, believe in celibacy. And yet, the government wants to force on a contraceptive mandate on them. So it's really crazy. And I'm wondering, too, whether, we're seeing the Supreme Court decisions being less respected.
It's interesting, Todd. It's almost as though people are taking on this view that the court is just another political voice that you hear. And it makes me wonder, is that credibility that's happening at that supreme level, starting to get tarnished so much that now you got lower level judges that are basically trying to act like we don't even believe that we even have to adhere to what we hear from the Supreme Court. Are we getting a little bit of that type of stuff happening now?
We certainly have seen that amongst various district courts. Trump derangement syndrome is a real thing. And, back in Trump 1, one of the things he's talked about in attacking the court system was ruling against him was Obama appointees, versus, Republican appointees and so forth. And, Justice Roberts said, in a sort of rebuke, we just have courts, we don't have these different types of appointees. I think the court is an institution. We've seen attacks on it. The system, has a liberalizing influence. In other words, justices are known historically for becoming sort of more liberal as they go in the Supreme Court. And most of the commentators and most of the institutions, law schools tend to be liberal. Institutions like the ABA are. And what you see is that when the courts aren't ruling the way they like, all of a sudden they're politicized. When they're ruling the way they want, they're standing up for, truth, justice, and the American way. And so, having an approach that isn't dependent upon the outcome to how you view the court system is something that I think that's difficult, quite frankly, for both sides.
Well, Vilo, maybe what this is maybe we do need to see something like this every couple of years because it's a reminder as to what really needs to be happening. And then, sometimes we don't have to wait 100 years to go back and see what the Little Sisters of the Poor ruling was. It looks like every couple of years we can, and it'll keep reminding us maybe what we're supposed to be doing from a religious liberty standpoint.
It could be, it's just amazing that that they are out there making a difference, helping people, and then they get penalized so much. And thankfully they probably have some people coming to their aid legal counsel that is taking their case for free. But for a lot of people, they might be up a creek without a paddle because going to Supreme Court, you don't do that on a nickel.
Yeah, Orlin, I think the federal court judge here is missing the forest for the administrative trees. The whole point of religious freedom, especially under laws like RFRA, is to keep the government from forcing religious people and institutions into moral dilemmas. They see this ruling as putting nonprofits back into the same conflict that the Supreme Court thought the exemptions had solved. And they warned that if the government can erase religious protections on a technicality, then religious freedom itself becomes shaky. So I think that we're going to certainly see this land at the Supreme Court again, because this is just isn't about health insurance and health coverage. It's about how far the government can go before it crosses the line into burdening religious exercise.
But Tim Schultz, in this day and age, moral dilemmas seem to be one of the greatest fundraising campaign tools that you could have. So it seems as though from a political standpoint, I'm looking for a moral dilemma to keep coming up because that's how the cash register rings in terms of paying for issues nowadays.
Yeah, Orlin, I think that's right. I think that fundraising imperatives are really behind a lot of the ongoing persecution of the Little Sisters of the Poor by attorneys general, by liberal advocacy groups. I wish it weren't so, but I do think that that is what drives a lot of this impact litigation. I think we know how this is going to end. I think the Little Sisters are going to, in the end, be okay. But as I said, the process is the punishment. But meanwhile, advocacy groups are kind of laughing all the way to the bank.
Well, you know, Todd, the process is the punishment, but some people say that about the whole legal profession, that we kind of make that process part of the punishment, and maybe we're as much as fault as those who are actually sending us into the courtrooms.
Well, listen, the legal system is what it is, and it's developed over, a couple hundred years or a few hundred years. There are attempts, I think, by judges and courts to sort of streamline things. But no, if you're having to go through it, as a party, it is often reminded about what it's like to go through on the other side. As a lawyer, it's your job. You sort of do it day by day. You can put it aside. But for a lot of clients, they can't.
Well, I'm going to let that be the last word, but it sounds like I'd like to say that this should probably settle this in a short order when we get to the Supreme Court. But my guess is 2 years from now, we'll be talking about this with some other state. Hey, Vilo, tell me something I don't know.
Going back to the first part of our show tonight, dealing with creation, did you know that an owl can turn its head 360 degrees, but it can't move its eyes?
Andre, tell me something I don't know.
The town of Dayton, Tennessee, the venue of the Scopes trial, turned the trial into a publicity stunt. It was the first celebrity trial, the first U.S. trial to be broadcast on live radio, and the famous moment where Clarence Darrow put William Jennings Bryan on the stand was moved outside, not just for extreme heat, but so the spectacle of thousands of people could watch it.
Wow. Tim Schultz, tell me something I don't know.
Well, William Jennings Bryan is really one of the most important Americans to never become president. He was a three-time presidential nominee. He also was Woodrow Wilson's Secretary of State. He was actually the Democratic nominee for president in 1896 when he was just 36 years old. So another one of those precocious wunderkinds who had a big impact on political life all the way up when he was a very young man.
Wow. Todd, tell me something I don't know.
Well, not to continue the Scopes monkey trial, I'm going to talk about the second half of our program, the Little Sisters of the Poor. One benefit of their ongoing litigation has been that for the last decade or so, they show up every year to the Beckett Gala celebrating religious liberty, and it's great to see them there. The other fun fact is, I'd say the unwritten rule, but I think it is probably written somewhere, is they are always first in line for the dessert after cocktail hour.
Didn't know that.
I'm gonna tell you something else you don't know. Second in line for that dessert reception is Todd McMurray.
Appreciate that, guys. Thanks again for being here with us, and thank you again for being here. Hope you enjoyed our conversation. Just remember, if it's about God and government, it's faith and politics. See you next time.